Let's talk about goals and expectations. I already indicated earlier what you can recover in the statute. If your goal under any civil remedial statutes, any employment law statute, if your goal is to go to trial at all costs and get everything you think you got coming to you, it's probably not going to happen. Because to really hit it big, I mean, we can get good wins, and I've lost lots of cases. I've won some, I've lost some. But where you get a big win, where you get punitive damages, back pay, etc., basically the sun and the moon and the stars all have to line up. It doesn't happen very often, although it has happened. 2, you need to expect that this is going to require some work on your part, whether you have an attorney or not. This film is to simply educate you and not necessarily to get business, because lots of people represent themselves in these cases. I turn cases down. There are reasons why I turn them down. But you need to be prepared to work yourself. And that requires essentially providing a lot of documentation that you need to get in advance. And you have to be in it for the long run. Now, how do you protect yourself? You know, the best cases are the ones you can document before you get fired. So if you have an employer who's pushing you to break hours of service, to record off duty while you're sitting somewhere in order to save hours, and you may want to do that, but just to let you know, falsification of a logbook is a felony. But if somebody's pushing you to drive bad equipment, there's things you can do in today's day and age. I don't know who doesn't have some sort of smartphone, Android, that has a recording device, and there are all but about 12 states you can record. You just Google eavesdropping laws and you can find out where you can record. Single party states where you're the party to the conversation and you don't have to tell the other side. We've got photographs. If you got a Qualcomm of your boss, I'll give you an example today. We have been working on a case today where a driver was on his 10-hour break. He was in the middle of it and he was asked to swap out trailers with another driver who couldn't. It was a rookie team. They couldn't get in and out of the truck stop in, I believe it was in West Memphis, Arkansas. The rookies couldn't get in there to swap trailers with this driver. He had disconnected from the trailer. They thought it was too tight. And he was instructed by his employer to drive under 10 miles per hour, a mile down the highway, and they said, and then you can turn it off and restart, and essentially it wouldn't show up on his e-logs. And he said, I am not going to break the law. Don't ask me again. And the employer said, I'm not asking you to break the law. I'm telling you to do your job or you'll lose that too. Now that's as close to a smoking gun as you can get. The company's telling him to interrupt his 10-hour break, drive at a low enough speed and short enough distance that it's not going to show up on his e-log. But in fact, he would have been falsifying. He refused to break the 14-hour rule, and we believe we can prove he paid the ultimate penalty of firing. But that driver was smart. He was clear in his statement to the employer, I'm not going to break the law. And he documented, he took pictures with his cell phone of the Qualcomms. Now those are things you can do if you're out there, if you're being pushed to break the law. You can take photographs of tires and show that they don't have 2/32 of an inch tread depth on a major groove pattern. You can audibly record an air leak. You can take pictures of broken mud flaps, hanging brake chambers, all sorts of things. You can take the truck en route, go ahead and take it to a service garage and have them look at it and write it up. We had a case last week where a driver refused to drive with a leaking airbag, and he took it to a shop and they wrote it up. The company declined the repair and they asked him to drive the truck back to the home terminal from Atlanta, drive it back to the home terminal in Chattanooga, and fired him for refusing to drive it. And they claimed, the employer said there was no air leak. We sent a service tech out, but we had the TA service order indicating that the company declined the repair, and 2, the driver took a picture of the airbag. Now these things that you need to do to protect yourself. either from getting fired or to preserve a case if you in fact get fired. If you don't have, if you're one of those people, you know, you're 60 plus like me and you haven't gotten around to getting a smartphone, or you're simply too cheap to get one, or simply just can't afford one, you can get other witnesses to take pictures, get names. If you're there and there's a Swift driver who witnesses some problem with your truck, get his name, ask him to look at it, ask him to inspect it. The ultimate thing you can do is, if the truck can be minimally driven safe out a gate, is to call DOT on yourself. Now that could result in points on your CSA score, but it certainly prevents you from killing someone if you're simply having to drive outside the gate on the shoulder. And it can certainly give you an ability to come back after a carrier who fires you illegally. So, in summation, you are empowered by the Surface Transportation Assistance Act. You have the power through today's technology to preserve evidence so you can prevail in one of these cases. So feel free to call us if you have any questions. I'm online. You can find us at our YouTube channel. Send me an email. You Google Paul Taylor Truckers Justice Center and you'll find me. I hope you all have a great cruise, and I'll have another video here recorded shortly on lease purchases. Thanks for watching.